The practice by successive governments from the 70s into the 90s was to deny disability payments to those in institutional care. And many of these people had profound disabilities and would have been reliant on the state to care for them and advocate on their behalf. But instead of advocating for them, the strategy by the governments during this period and subsequent governments has been to suppress advice coming to Cabinet that if those disabled people sued the state for payments, their cases were likely to succeed. This affected thousands of people in up to 140 institutional care homes. It has been estimated that this affected somewhere between 4,000 and 10,000 people during the time the payment was made by the Department of Health, and another 2,700 after the Department of Social and Family Affairs took over payments. These revelations, as shocking as they are, should not come as too big of a surprise if we consider the other scandals involving successive governments down through the years, where they have tried to deny people rights by concealing information and settling on the steps of the court. And I am thinking of those affected by thalidomide, Sophia Falperite, the cervical check scandal, the Mother and Babies Redress Scheme, and of course now to the relation to the nursing home fees. So we need full disclosure and openness from the government and from those who were in positions of power in relation to the government's heartless political strategy to withhold disability payments from those in residential care who were entitled to it, and the subsequent concealment of this strategy by successive governments since. And this must involve full cooperation and transparency from government, including acceptance of any requests from committees for ministers to address the matter. The current Attorney-General has concluded that the state had, and I quote, no positive legal duty to make retrospective payments on the disabled person's maintenance allowance. But this simply begs the question as to why the cases brought against the state were settled. Minister of State Richmond, in response to a question I raised on this issue yesterday, quoted the AG's from his report saying that it is sometimes tempting to resort to generic stereotypes about the state being in some way unfair to its citizens when they are deprived of benefit and bring legal proceedings challenging this deprivation. And Deputy Richmond went on to state that the logic of such a perspective is that the state has unlimited resources, must concede every court case that is brought against it, and must fund every claim for compensation and redress that is demanded of it. But this misses the point, or more importantly, tries to deflect from it. Of course it is the case that not all challenges against the state are well-founded. Of course the state has the right to defend itself against a legal challenge. And of course the state should protect the taxpayer. However, the advice coming to Cabinet was that if those disabled people sued the state for payments, their cases were likely to succeed. So if this is not a case of challenges which were unfounded, and when the state had the opportunity to defend its position, it decided to settle these cases at the court steps. And as for protecting the taxpayer, it seems this is only of interest to the government when it is in relation to vulnerable people. The state did not fight the church in court to get it to pay for all the abuse it inflicted on children. It has not fought those who supplied faulty cement blocks or the builders of substandard apartments. In essence, what this and previous governments do is pay out to those with power and means, even if they are not primarily culpable while denying payment to the weak, even when this obligation is utterly undeniable. So, once again, I would like to reiterate that what is needed here is full disclosure and openness from government and from those who were in positions of power in relation to this heartless political strategy from the government to withhold disability payments from those in residential care who were entitled to it, and the subsequent concealment of this strategy by successive governments since. And this must involve full cooperation and transparency from government, including acceptance of any requests from committees for ministers to address the matter. I just also to say, Minister, you and Minister Humphreys are going to review this and look at all the documentation and come back to us within 3 months. I hope that you will be guided by the UNCRPD and ensure that the review is based on the rights of people with disabilities. We shouldn't need a convention to tell us how disabled citizens are treated or should be treated. But it is because of actions just like this by successive governments that we need a convention. And Article 28 of the UNCRPD states, parties recognise the right of persons with disabilities to social protection and to the enjoyment of that right without discrimination on the basis of disability, and shall take appropriate steps to safeguard and promote the realisation of this right. There are other rights there that guarantee legal capacity, guarantee right to information and guarantee justice for persons with disability. All of those things have been denied to the people in this case, but you have an opportunity to correct the mistakes of the past. Please do it.
Thank you.